Contributors to this book. They will be speaking about their experiences as judges. We have 2 copies of this book if anyone's interested in checking one out from the library downstairs. First, I will introduce Judge Gail Chang-Bohr. In 2008, Judge Bohr was elected as the first Asian American judge in Ramsey County. She retired in 2014 and has been serving as a senior judge for the state of Minnesota. From 1995 to 2008, Judge Bohr was the first executive director of Children's Law Center of Minnesota. Prior to her time at the Children's Law Center, she clerked here in this building, or maybe was it this building?
It was this building, yes.
For Justice Sandy Keith on the Minnesota Supreme Court, and she also practiced law at Faegre and Benson. Judge Bohr also serves as an international consultant with the National Center for State Courts, Trinidad and Tobago Juvenile Court Project. And she serves on the advisory board for the Minnesota Asian Pacific American Bar Association, the executive committee of the Infinity Project, and the board of directors of Lawyers Concerned for Lawyers. We also have with us Judge Edward Wilson, who was appointed to the Ramsey County District Court in 1987 and served until he retired in 2018. Judge Wilson worked in family, juvenile, civil, and criminal divisions of the court and was the presiding judge of the criminal team from 2008 to 2013. And he also currently serves as a senior judge. Prior to his appointment to the bench, Judge Wilson was an attorney at the Neighborhood Justice Center in St. Paul, was also an attorney with the Legal Aid Society of Minneapolis. And in 2002, Judge Wilson was nominated by the U.S. Department of State to serve as an international judge with the UN mission to Kosovo. While serving in Kosovo, he presided over cases involving war crimes, homicide, ethnically motivated crimes, drugs and weapons trafficking, and organized crime. Please help me welcome our guests.
Well, thank you so much for the invitation to be here. As I said, this is the best state law library in the country, as far as I'm concerned, because I spent many, many hours in the library, and in this room as well, actually, for other things that I was involved in. So Ed and I got to write chapters, a chapter from me, a chapter from Ed, Judge Wilson, in this book. And so what I wanted to just talk about first, and we welcome questions at any point, okay? Because frankly, we didn't really rehearse what we were going to say. So just bear with us here. How did we get invited to write in this book? And there are 13 chapters in this book. And here it is. So the judges are from around the country. And here we are, 2 of us in Ramsey County who got to be in the book. So this is very special for us. The book came about because there are 3 judges in Washington, D.C., part of the Superior Court, the federal district court there too, who wanted to write about, I think, some of their cases, and they're also in the book. And then they went around asking how you get, I don't know that they even looked for representative samples, but they wanted to find people from around the country who were willing to participate in this project. And the reason that we became involved in it is, as Liz mentioned, was with the National Center for State Courts. And the person there who was the head of the International Division, Joanne Richardson, and I had worked together, and Greg Mize got to know her. Greg Mize is one of the editors, and asked her recommendation for somebody who could write a chapter. And Joanne mentioned my name, and so when I got the call, I always also asked, is there somebody else I could recommend? And here we go with Judge Wilson. So that's how we both got involved. Let me just tell you a bit about the chapter that I wrote. And I'll tell you the name of the chapter. I don't know it by heart. I always have to go back and look. It's called A Judge's Hidden Struggle, Overcoming Judicial Culture. And you've all worked with judges here, right? And you understand that there are certain ways that you do things, and that's the way you do things, right? So one of the case that I chose to write about was a child custody case in which the parents of an 18-month-old child had decided on what their parenting plan would be. And the parenting plan was for this 18-month-old child to move from one parent to the next every other day. Okay, now think about what that means. We have an 18-month-old child and move in households, their crib, where they're going to sleep every other day. Now, when I was working in family court, when you had situations where custody, which is usually, very disputed, becomes very rancorous, when you have a couple who comes in and says, this is what we want. So they came in with an agreement, a proposed stipulation. They were running it by me to see what I thought and if I would sign this thing. One of the parties, the father of the child, this was an unmarried couple, by the way, had an attorney and the other person did not. But so the proposal was something that they both agreed to, that they would share legal custody, share physical custody, and this parenting plan. And so they wanted me to approve this. Now, I said, well, I thought about it, and I thought, well, it's their agreement, and we don't have to have a trial, and, this is good, right? This is a culture we're in. Because when you have agreements between parties, I think sort of the trial goes away, usually. And so I wanted to really spend some time thinking about this because as Liz mentioned, I think she did, I was a social worker for 20 years before I went to law school. So I worked with families and children, and it was very clear to me that when you disrupt a child in this way, that it doesn't always work well for the child. It might work well for the parents, but not for the child, who really need a stable, consistent environment. That's my view as a clinical social worker. It's a view that I've carried forward in most of my work. And so it really bothered me that we had a situation having a child move every other day. So I wasn't really, and that's where this became a tough case for me, because it was, do I follow what this couple wanted to do and not have a trial on the parenting plan, or, what I felt was imposing my views about child rearing on the situation. And that to me was the piece that made this case tough. I'm going to stop there because I think if you really want to know what happened in the case, you can read the chapter. No, we'll go over that later. But I do want to give Judge Wilson a chance to talk about his case. We'll come back and forth on this, okay?
Okay, but just a brief introduction as to how I got to be nominated by the Department of State. That sounds really important in August, doesn't it? Nominated by the U.S. Department of State. It really wasn't as impressive as it seems to me when I say it. What happens is that back in 2002, one of the U.S. district judges, John Thunheim, who had done some work in Kosovo on court building projects, was told that they were interested in recruiting American judges to work there. Now, as you probably know, after the war in Kosovo, in which NATO essentially bombed Serbia, and the United Nations took over Kosovo, or administered, I shouldn't say took over, that's not the right word, but they began the administration process over Kosovo. They set up a judicial system. And they had to set up a separate judicial system because, quite sensibly, the local judges, the native Kosovars, would not be trusted to be fair in matters concerning Serbs. They've been at each other's throats for hundreds of years, literally hundreds of years. And the Serbs have always thought of Kosovo as part of their country, and they still do today. And if forces pulled out, they'd be at each other's throats tomorrow. That's just the nature of things. So under those circumstances, it was necessary to set up a separate judicial system, at least for the time being. And so the United Nations set up not just a judicial system, but a whole governing body called UNMIK, the United Nations Mission in Kosovo. And as part of that, they brought in international judges. Most of these were European judges. For whatever reason, and I don't know the reason, they were not able to fill the need with just using European judges. So they called on Judge Thunheim to ask American judges, and thankfully he did not ask American judges, he asked Minnesota judges to participate in this. And so I was one of the people who applied, and I was fortunate enough to be appointed. One thing I want to say before I forget it about this book, Tough Cases. When we think about the word tough cases, the thing that you often think about is something that is legally challenging, something that is perplexing to you in some way, that's some hard, conflicting laws that you have to figure out. As I read through all the chapters in the book, and I hope that you'll have a chance to read through all the chapters in the book in all seriousness, and I say with no undue modesty, it is a good book. I'm glad you didn't laugh, because it's good. The reason that these cases are tough is not because of the challenges of the law itself. It's because there's tensions that sometimes come in place even when the law is kind of clear to you, as I think Judge Bohr was just saying. The law is pretty clear in some cases, but sometimes you have to figure out the way to make the right decision, given what the law is. And I'm not by any means talking about stepping around the law. That's not me, as anybody who's ever seen me in court will tell you. But you sometimes have to figure out what it is, how it is that you apply the law in this particular circumstances. That's what makes a case tough sometimes. And that's what I think you would find in each one of these chapters. And certainly it was true of the cases that I talk about in my chapter. I actually talked about 3 separate cases. One was involving a war crime, actually not a war crime, it was involving a man named Salih Vaseli, who was accused of killing a rival of his, a political rival. They're both Kosovo Albanians, and they both had been involved in the war against Serbia. But after the war was over, they were jockeying for power who was going to take control after the war in Kosovo. And so Salih Vaseli was accused of having killed Commander Drini. That was his nom de guerre. My French is bad. The long and the short of it is that we had a really long trial over several months, and we hemmed and hawed, went back and forth. We did not convict him of the actual murder, but he was convicted of the conspiracy to murder. It was kind of a compromise that we reached. That decision was overturned by the Kosovo Supreme Court. For reasons that I am not aware, I don't know to this day. But in any case, he was retried, and he was convicted not only of conspiracy to murder, but he was convicted of murder itself. So that also obviously raises these, what we would consider constitutional questions in the United States about double jeopardy and so forth. But that's Kosovo for you, and that was provided for in the Code of Criminal Procedure. The second case I was involved in there was one involving a man named Arben Ramadani, who actually went to Turkey, was actually a Kosovo citizen, a citizen of Kosovo, but had went to Turkey and committed a murder there. Turkey did not have, at that time, Kosovo was not recognized as an independent nation. As of now, it has claimed its independence and is recognized by most of the countries in the world, including the United States. Obviously, Serbia does not recognize it, and I don't believe Russia recognizes it either. But in any case, there was no extradition treaty between Turkey and Kosovo, and so what that involved was it required us to go there to Turkey. And when I say us, I mean myself as the presiding judge, the defense attorney, the prosecuting attorney went there. The defendant did not go, which raises other, what we would consider constitutional questions, because we're examining witnesses. All the chief witnesses were in Turkey. But again, that was something that was allowed under the Kosovo Procedural Code. And the final case that I had was a man named Buyer Basha. He was the head of an organized crime family in Kosovo, and he and his family and associates were committing a number of armed robberies throughout about the city in which I was stationed, which is named Prizren, Kosovo, the second largest city in Prizren. They were well known throughout the city. They always had been. They had a bad reputation. They did robberies, burglaries of all kinds over the years, and everybody knew this. But in this particular case, there were several charges of robbery against him and his family and his friends, and we heard evidence, again, over a period of several weeks. This involved break-ins into people's houses at night, holding their family at gunpoint, carjackings on the street, burglarizing jewelry stores, and so forth. There was a lot of anguished testimony from a lot of people about this. But as the evidence came through, it became clear to me that there wasn't very much there was nothing that I could look at that would say, this points to Buyer Basha and his family having done these particular crimes. With one exception, there was one case to which they admitted, but for the vast majority of counts, and I think there were something like 15 different counts, there was no evidence. There was lots of jewelry that was brought in, but no one could even identify the jewelry as their own, because these were jewelers who were being robbed, and they all had this particular style that was unique to Prizren, but none of it had identifying marks. There was no evidence of any facial identification of anyone, because these happened at night and people wore masks. There was no license plate numbers on the cars that were used in the carjackings. There was no fingerprints found in the jewelry stores that would connect any of the people to these robberies. So at the end of the case, and I'll sum this up quickly, at the end of the case, we went back to the room to deliberate, and I was the presiding judge in the case, and there was 3 lay judges. That's the system that's used in Kosovo and actually throughout Europe. Keep in mind, we're operating under the civil system. There's no jury there as we know it. There were 3 lay judges who are not legally trained, and 1 legally trained person there, a lawyer, and myself acting as presiding judge. The others were actually judges as well. They were not a jury, again. So we went back, we started our deliberations, and the first thing that one of them said was, they're all guilty. And I looked around the room, and everyone else nodded their heads in agreement. They're all guilty. They've been bad people. They've always been bad people. We know that they did this. And as I listened to him, I wondered, have you been listening to the same evidence or lack of evidence that I've been listening to for the last several weeks? And that was kind of, I won't say I was shocked, because as I said, I know this is a country in which people have not been operating with the same kind of legal system with protections that we have, and the same kind of understandings that we have, and the same vigorous defense that attorneys put up in our system. And so it seemed to me kind of, I knew it intellectually, but it's still rather shocking when you are faced with the fact that there can be no evidence in a case. In fact, if this was in the United States, this never would have gotten beyond the probable cause stage. This would not have gone to trial. But there could be no evidence, and that people would be so adamantly certain that these people should be found guilty. So I kept arguing back and forth, trying to say, well, there's no evidence, there's no fingerprints, there's no identification, there's no confessions, except for that one case. And finally, the lawyer, the legally trained person, finally agreed with me. He said, there's no evidence. And of course, once one of the locals said something, I guess that's what they needed to hear. What do they care about some guy from Minnesota, what he has to say? So after that, we came to an agreement, and we found them not guilty on all the charges except for the one to which there had been a confession. Now, I think that case is the most important one in the book. It kind of highlights how important it is to have a system in which people are afforded all of their constitutional rights. And these, when I say constitutional rights, these are things that are not really unique, should not be unique to the United States. When I say that a lot of things are provided for in the Kosovo Procedural Code, they still are required under that code that people be found guilty by something, the equivalent of beyond a reasonable doubt. And yet, because of that history there, people were not really putting any faith in that. And because also, frankly, because of the kind of representation that the defendants received was a very low standard, to be blunt. So I say these things because I say it more and more as the more I think about it. We have so many problems in our justice system, but when we compare it with what is going on in other places, we really should take a moment and feel some gratitude that we have the kinds of representation that we have a jury system that works like it does. Thank you. So I'd like questions. We need lots of questions. There's a lot of people here. Were you going to say something further, Judge Board?
Well, I don't know. I think that's just cue for me to say something, right? So I realize that, when you think about the case that I just described, the biggest part is, as Ed mentioned, is, the law can be clear about things, right? But there's a certain part within the law, as judges, you're allowed your discretion. And I think that's where sometimes people, maybe judges, get themselves into situations where they sort of go, oh, why did I do that kind of thing? But or other people are going to say, why did you do that? But I think what's important when I thought about my case, because we talk a lot about the biases that we bring to the job, right? We come in with our own experiences, with our educational level, all of these things that really play a role in how we decide cases. And I think it's important as what my struggle was really when I get to make the decision about who has custody, right? Or how this parenting plan is going to work. You really bring in a lot of your own thoughts about children into that mix. So I thought it was important, and what made the case hard was because I spent so much time worried about, was I bringing my own biases into this case? My bias about child rearing, my bias about what's best for children. And that to me was really the crux of why it was a tough case. So to get to, how you deal with those biases, and I think you probably, working with judges, see this probably when they're talking to you, and certainly when I clerked, I mean, we always found that the best part was just having these discussions, is taking a look at that bias and saying, okay, I recognize what this is now, and I have to figure out a way to make this decision and not make that get in the way. And we talk about implicit bias in so many different ways, right? We bring those kinds of experiences to the job. And I think it's important as judges that we spend time really looking at it and making sure that it's not getting in the way of the decision. I don't think you make the decision because of the bias or in spite of the bias, but you have to recognize you have a bias. And I think that's where, for me, was the struggle of, was it because I think I know so much about child rearing that this became such a big deal for me. So as Ed says, it's not because it was a tough legal question, but I think we bring our own humanity to the decision that we do struggle with some of these beliefs that we have about what's the right thing to do. I think I wanted to make sure that you understood what we were getting at about why it's a tough case. I think when you read the book, you'll see that really there were not tough legal questions. It was all the other things that came up that made the case tough. Some of it external and some of it, well, the Terry Schiavo case, for example, there's a lot of political issues that came into that case. The Elian Gonzalez case, so that's also another one. But when it got right down to what the judges were working on, I think they really felt that they had all the information they needed to make the right decision. But those other things got in the way.
I'm sorry. Go ahead.
No, go ahead.
I was just wondering, I would imagine and I've heard that being a judge can be kind of a solitary role. And I'm wondering if you have any suggestions for attorneys as to how they can be more helpful with tough cases to kind of assist the judges, if you have any thoughts on that?
Well, attorneys are certainly going to come in with their own advocacy for their side of things, right? But I think if you can lay out as much as you can, where, I don't know. I mean, when you're an attorney, you really are, this is what my client wants. How does that work? I think we probably turn to other judges for that kind of back and forth, and really, and I did in my case, really talk to several other attorneys about, if this were your case, what would you do? And you see, the advice I got was, it's an agreement, it's a stipulation, you really should follow that. And I'm thinking, oh, no, I don't know if that was the right thing for this baby, right? So that's some of the things, but you work on that with bouncing ideas off other people. I think when it comes to discretion, that's really a hard thing to say, how attorneys can help with that.
Yeah, I don't really see attorneys as helping us with the tough cases because, like Judge Moore just said, it seems to me that obviously you're there to help your client. And what is helpful, obviously, is the basic common sense kinds of things, is if you are diligent and hardworking and you present in an honest way your case. And obviously, I know that you're always going to slant things as best you can towards your client, but at least, as long as it's honest, that you're not being misrepresenting things, and and that doesn't happen very often. People outwardly misrepresent things. As long as you are honestly presenting things and you give us all the relevant law in the case, that's all that we're looking for. I think it's what judges are would usually look to as other colleagues, I think, more when we got a particularly sticky situation. And I have found, even that has its limits, because everybody is going to have their own particular bias, their own particular way of looking at things, and it might not be in line with the way you're looking at it in terms of exercising discretion. We all have very different ways of how we think the law ought to work. I mean, some people have a very expansive view of their discretion, and others have a very limited view of their discretion. And it simply comes down to bouncing off all of these ideas off of people, but in the end, you just have to simply do what you think is right. It's as simple as that, and as complicated as that.
There's a question back there, yes?
When you were considering which cases to write about, what were some other top contenders for tough cases to write about that you've had?
It's so long ago. Yeah.
No, for me, there was nothing else that really came close to the cases that I wrote about.
Yeah.
Most of the cases, I was in the criminal area, adult criminal, for most of my judicial career. And generally speaking, those cases, again, are not very legally, most of the time they're not legally tough, I have found. Yeah. Once you get to know the basic laws of criminal procedure, they're not legally all that tough. They're generally fact-based. And the question becomes, criminal law, actually, as I think about it, though, is an area in which you do exercise, in sentencing, you do get an opportunity to exercise a great deal of discretion. But it seems to me that most of the cases, factually, you don't decide the facts, usually it's a jury anyway. Legally, most of the cases are simply not that difficult.
Yes.
One of the things that I find really interesting about the position of judges is that they have to step into people's lives and sort of make sense of them on a very regular basis. And I guess I was wondering if you could think of any tough cases in your careers that required or really hinged on understanding cultural norms that were different, whether generationally or nationality or just the way that people operate in their homes that were different than you were familiar with, that kind of complicated the case for you?
When you say the cultural piece, I think what's important, sometimes you have stipulations where the parties have unequal power in the relationship. And those always presented a problem for me, because I could tell from the culture that I know, that then men might have more of the power, the economic power, as well as a familial power, because culturally they're more looked up to. And so when I would get stipulated, I'm talking about family court now, some stipulations, I would get them there too. I really paid attention to what was being asked for and what each party was going to get from this. And sometimes you'll get things, I'll throw this out, it happens quite a bit, but I hope no judge is going along with this, where there's no child support. And you go, Oh, well, this thing doesn't have child support. You know, you have to have child support. Oh, I don't know, need it, Judge, says the woman. And I say, well, wait a minute. You have to realize child support is not your right, and it's not his right, it's the child's right. Every child has a right to child support. So we're going to take a look at this a little more closely. So that's one way that I see this happening. And I do step in. I just say, can't do it that way. We're not, this will not work. So it does happen. And I think just understanding the culture is important, because it's so easy to look at these stipulations and say, well, this is the agreement, you know, and she signed off on it, and you can ask all kinds of questions. But sometimes the culture doesn't allow women to have that voice, right? And sometimes you do have to step in a little bit more, I think. And I'll give you an example of the ones like this, where it's a long-term marriage, has been a house, husband, they're now split, and he gets the proceeds from the house, he gets a car, he gets all kinds of things. And I'm looking at this and going, okay, how long have you been married? You know, how much did you get for the house? All those questions. And I have to say, in one case, I did say, look, because this woman, they had like 8 kids, was having to take the bus. And I just said, you know, she needs a car. I think what we're going to have to do is figure out how she's going to get a car so you can do this. So I probably was a little more active, but it just appeared to me that there was a grave injustice that was going to happen if I signed off on any of this. So that comes from my understanding about some of the cultural pieces, okay? And just calling them on it. But, you know, you can't do it all the time, right? But I think it's important that anytime you see a stipulation that you really understand are both parties really operating on an equal footing here.
You know, another thing to think about, and I don't know if this is part of implicit in your question, but there are more and more, with increasing frequency over the years, the people who come into our court system come from increasingly diverse backgrounds and diverse cultures. And there are people come with their own sets of cultural rules, which we do not recognize in this country. Some of the things that people in their culture that is acceptable, not just acceptable, but is a cultural norm, is flat out illegal in our country. And so I think as a judge, it's good to be aware of these things, but I would never allow myself to be swayed or in some way do something that I felt was stretching the law to accommodate someone else's cultural needs. I mean, we have to work within the framework of this society and its norms. I'm aware, I say this, but I'm aware of a case in which, for instance, someone was given what I thought a break that they would not have gotten had they not been of this particular culture. And, you know, it made people feel good at the time, but, you know, I have to ask myself, if you do that for that person, what about the next person who comes into court who's in a similar situation that you won't do it for? So it seems sometimes it makes you feel good to do certain things, but when you look at the big picture, are you doing more than helping that person? Are you also, in a sense, you are discriminating against other people to whom you don't give that benefit? And so that's why I'm very careful and very cautious about doing things. Well, frankly, I would not do something simply because it seemed to be something that would be in somehow conforming with someone else's culture. Recognize it, respect that they have these differences, but you have to explain that we have to live within the norms of our society now that you're in this society.
Question from the webinar. Following up on the earlier question regarding helping the judge, the question regarding helping the judge is, how do you think like a judge? What is important to a judge that a lawyer may not think important or pick up on?
Wow, how do you think like a judge? Well, we have all the answers here, right? You're all clerking for judges. How do you say? Well, we're called on to make decisions, and you have to make decisions. You can't put it off forever, right? You can spend a lot of time thinking about. You research the law. You've looked at the arguments. You've listened to everybody, and now you have to make a decision. And I think it's important for us to realize that sometimes making decisions are not easy for judges. And because I think you can come out both sides of any decision you make. You're going to make somebody happy or somebody not happy. And, I suppose, what do people say? If both sides are equally unhappy, you made the right decision. I don't know about that. But so think like a judge. How do you think? Before I became a lawyer, there was that thing about think like a lawyer, right? Have you all figured that out, how to think like a lawyer? I think you pay attention to the details. You listen, and you must listen very carefully. You've done your research in the law, and it really gets down to that bit of discretion in some cases where you get to make a decision. Sometimes you don't. If the law is not clear, you know where you're going to come out, right? I suppose if I were to think about how do you think like a judge, I think I approach things with an open mind and really work my way to what does the law require me to do? Do I even have any discretion here? And go from there. If you have discretion, I think you, as I said earlier, is to really make sure you understand your biases and how you might come out on something and really examine that to be sure that you're really doing the right and just thing. We think we are being fair and just, and that's probably what I would say. Thinking like a judge is how do you come out with a fair decision and a just decision? It's a roundabout way to answer a question.
Well, let me see if I can summarize it.
Encapsulate it. And I know we always do this. I go first, and then he comes up with the nuggets.
Well, essentially, I basically agree with what Judge Boris said. If there's one quality that I would point to, but before I even talk about that, let me just say this. When you talk about thinking like a judge, implicit in that is that there's a lot of cases that require a lot of thought, and let me just tell you a little secret, 99% of the cases that we do are pretty clear. You don't have to figure them out. The law is clear and the facts are pretty clear 99% of the time. That might be a slight exaggeration, but that much. But in that 1% of cases that are not so clear, I think it's really extremely important that your most important quality as a judge is being able to listen very carefully to both sides, or more if they're more than that. Listen carefully and thoughtfully, and to avoid a prejudgment as much as you possibly can, because let's face it, we all come into cases with a certain bias and a prejudgment about how we think it should be. But you have to put that aside. Even in the most, when I said 99% of the cases are pretty clear, maybe that's a little exaggeration. But even when it's a clear case, when someone comes into court and argues to you about what you think is a clear case, your average DWI case, for instance, your first-time DWI case, you know before, you think you know before they start talking what they're going to say. And most of the time you do know what they're about to say, but still you need to keep your mind open, keep your ears open, because it might be that one case out of 100 where something is a little bit different, just a slightly different take on things that causes you to make a slightly different decision. So I think that listening, being the ability to listen very carefully, is an extremely important quality. And it's easy to say, wow, that doesn't require any intellectual ability to listen. It doesn't, but it does require a lot of patience. And that's the second thing that's extremely important, is being able to listen even when you don't feel like it, even when you're tired, even when people are annoying, is having patience. Those are the qualities that I think that I always have thought have been extremely important. And it goes without saying that you need to be, again, put aside biases and prejudgments and act in a fair and impartial manner, which is not always easy to do, because sometimes people will push you in a way that makes you want to get back at them, because there's a human being inside those robes, and it's not out of the question that you will feel angry at people, and you have to put that aside. So being able to control yourself, your emotions, is another part of it.
And to follow up on that, Ed, I think one of the things I'm trying to think about, why would somebody ask a question like, how do you think like a judge? But I think the main thing for us as judges is we treat every case as the most important case there is, okay? That's a little hard to do when you just get the run-of-the-mill kinds of things, right? But it's an important case to that person who's standing in front of you. And you have to remember that. And that you have to be thinking in terms of how do you make this person leave your courtroom feeling that they've been heard and that they're getting a fair decision. And I think the hard part of some of the decisions that we make, even though it's black and white or it looks that way, that it's clear cut, is how we sometimes have to write our orders in a way that sort of also gets it across to that person that you heard them, you listened, but this is just the way it's going to be. And I don't know, as law clerks, you get to write a lot of these orders, right? And so you're really thinking in terms of how is this going to come across to that person who's going to receive this in a way that they feel respected and heard, even though the decision went against them. And, you know, the things like that you spend time doing as a judge, probably more so than, okay, no, we're not going that way. But how do you make your order be, be something that somebody feels that they were heard? And sometimes, you know, what I've done in some orders, I remember this so clearly because my law clerk and I talked about it, you know, was just say, you know, I understand how hard it may be for you to do whatever, but this is the way it comes out, right? The law is just very clear on this. So, you know, when DWIs, when people are trying to, they have all kinds of ways to argue that issue, but it's there. I mean, we have the proof, we have everything, so you have to follow the law and go that way, but you can also tell somebody, hey, I understand how hard this might be for you, but this is the way it's going to be. So, that's just to fill out what I thought was also some of the things that, you know, especially when people are thinking about being judges, that what is it that you really want to get across? And I think people feeling that they've been heard is an important piece. Yeah.
This kind of ties into what you just said, but I remember listening to Justice McKay talk about when she had started thinking about becoming a judge, and she had a mentor who told her a couple of times, you're not ready. you're not ready. And so, do you have any thoughts for anybody who's thinking about maybe pursuing, trying to become a judge? Any kind of cautionary notes? Any things that are good to kind of have in your background to prepare you? Anything like that? Words of wisdom?
Words of wisdom. Yeah, first be wise, okay? I think you just do a good job in whatever you do, because in the long run, that's going to serve you best, your best work forward. Be respectful of your fellow lawyers, be respectful of the court system. I think anything that, the whole thing about judicial temperament is something that we don't spend a lot of time talking about, but we can certainly know when judges are not being well-tempered. And I think it's important to sort of hold yourself in check. But it's one of those things where, you want to say, okay, be nice, but it's really not just that. It's how respectful you are, how much you pay attention to what people are telling you, how you treat your fellow lawyers, your clients, doing all the things that we're taught as lawyers to do. I mean, the lawyer's responsibility, ethics, those really do give you a way to do good work if you follow those rules of ethics, right? Be diligent in your work, client communication, your trust accounts, all of that. Those things that you do sometimes come back to bite you if you haven't done the things that you should have done in the right way. So I would say just be very ethical in whatever you do.
Yeah, it's extremely important, obviously, that you maintain this high standard of ethics. If a person was interested in being a judge, I would suggest that that person look at as many judges as they possibly can, look at the behavior of as many judges as you possibly can. And I had the opportunity when I was practicing as an attorney to appear in front of every judge in the county. And I got to see a lot of different styles, and I learned something from everyone. I learned what to do and what not to do, just from watching all of these judges. And I thought that always was helpful for me, because it's just so important that you get to know how people react in different circumstances, how judges think, how they approach cases. And the only way you get to do that is by just watching them, observing them in all sorts of circumstances. That's what that's the one thing I would think of in terms of preparation. I mean, if there's any specific preparation, that's what I would say.
We have a couple more questions from the webinar.
Okay.
The first one is, you mentioned the need to stay calm and control your own emotions. What do you do to help keep an emotional equilibrium? Meditation, prayer, etc.
I'm just a calm guy. No, I mean, there's a certain, I'm halfway serious when I say that. So I haven't done much in the way of meditation. I've tried it, and I have never been able to keep up with it. What I've done, though, what I've always done for years, is I try to stay physically active. I try to work out as much as I possibly can. Try to have other interests in life other than being a judge, because there's more to life than your work, obviously. So I think everybody needs that outlet to get away from things, and that's what I always did. Every morning I devoted to trying to just exercise when I'm not thinking about anything else, but just trying to exercise.
And I would go for long walks after after a dead court, the first thing I did was just walk. And even if the phone rang or whatever, it was, I can't talk now, I have to go do my walk. And I think when you walk in and by yourself, for me, it's not a social thing. I don't go with friends or do anything. I just need to be by myself. And I think about how the day went and how things, who did what and all the rest of that. And then I just, okay, that's it, done with that. So you can play it back in your head and then just let it go. I think if you're ever on the bench and somebody is really making you angry, the thing to do at that point is to call a recess and just go. Because I think if you just sit there and you suddenly get more and more angry, you might suddenly find yourself saying things that you wish you had not said. So I think it's just better to go calm down and come back. And as a judge, you can call a recess anytime you want, right? So just do it, because it will help. It will really help to just be away from it. And if you need to, you call another judge and say, I can't believe what that person just did, blah, 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 blah. But then you can go back and be calm and deal with the situation. People will make you mad a lot of times. Okay, sometimes it's the lawyers and sometimes it's their client who's really being not very helpful. So you want to be able to step back and understand that that's what's going on, but you're not going to take the bait. You're just going to be yourself and calmly go back in and deal with the situation. So, and there was another question?
Yes. Lawyers are often trained to have a theory of the case. If a lawyer has a good theory, does that help the judge or not?
I think it does.
Yeah, it does.
I think it definitely does. Assuming it's a reasonable theory. I've heard lots of crazy theories, but no, as long as that's what we would want. We'd want a well-reasoned, thought-out analysis about why you think your client should prevail. And you see that all too rarely, unfortunately. Usually, it's people are coming up with ideas I shouldn't say usually. That's not fair. But often, people come up with ideas that simply are kind of off the wall, to be frank. Yeah. And it gives you so much more credibility if you have researched the case and you lay it out logically than if you come up with an emotional argument. You have so much more credibility that way, and it gives you an automatic leg up. Because, unfortunately, as I say, we don't see it enough that people come up with. It seems so obvious it should be that way. A logical, thought-out theory of the case. It's actually kind of rare.
I think what we like to have well-prepared lawyers. So whether you have a theory of a case that's really out there or not, just be prepared to take argue it and back it up with the legal piece, right? It's not just yammering, but you got to show us what is the law behind this, and be prepared to tell us what the case law is, because that helps a lot when we have to make a decision. Yep.
I have a question for Judge Bohr, and that is, how did you ultimately decide the case? Did you allow your 20 years of experience as a clinical social worker to inform your decision? And if not, did you at least push back against the parties on their parenting plans?
Oh, I think, it's sort of who you can't just put aside all those years of experience, right? Because everything comes in, as I said, when you're a judge, you really, you don't know this, but you are, because you're the sum total of your whole life there. So how do you push back on people with a parenting plan? My idea in this case, was really to have them do an evaluation, to get a psychologist involved, to do a a child evaluation to tell me and have them prove to me why their plan is in the child's best interest. So in the end, I was not going to just come up with this. They had to show me why this was in the child's best interest. Ultimately, I didn't have to do that, but that would have been where I would have gone with it in that kind of situation, because, as I said, I was so concerned that it would be my decision, and I didn't want it to be that. I wanted them to tell me and prove to me why their plan was going to work best for this child. Not, in the child's best interest, not just the mechanics of it, but just how would this help her development? How would this make this child feel secure? So that's the way I would have approached it. Ultimately, I didn't have to do that, because the case, if you read the chapter, it just sort of imploded. Both parents ended up not being able to be parents, turns out, and grandparents stepped in with a third-party custody petition. So that didn't happen there. But I was prepared to say, okay, we'll do the evaluation, you guys pay for it, and then let somebody else tell me why this is in the child's best interest. But what happened was I paused the whole thing because I was concerned, right? So it was my thinking about it that really brought me to the next stage. Any other questions?
Well, we're at 1 o'clock. If there aren't any more questions, thank you so much.